Good afternoon and welcome to the 2020 LSC Visits webinar. My name is Dr. Dina Chafee-Scott. I'm the Training and Technical Assistance Manager at Legal Services Corporation, and I'm with the Office of Compliance and Enforcement and the Office of Program Performance. I'm joined today by Roxanne Caruso, the Assistant Inspector General for Audit in the Office of Inspector General, Daniel O'Rourke, the Assistant Inspector General for Investigations, Office of Inspector General, and Laura M. Rath, the Director of the Office of Compliance and Enforcement, and finally Joyce McGee, the Director of the Office of Program Performance. We have a couple of objectives today that we hope we can fulfill in this webinar. The first is to explain the reasons for and protocols of visits conducted by LSC, including visits conducted by Office of Inspector General, the Office of Compliance and Enforcement, and the Office of Program Performance. We hope this webinar will provide you with an opportunity to ask questions about the purposes of visits, including what you can expect with pre-visit requests, on-site logistics, and post-visits reporting. Before we get started, a couple of reminders. You can find a copy of today's webinar at lsc.gov under Grantee Guidance. Additionally, if we get questions that we are not able to get to today, we will follow up soon with an FAQ question response. Additionally, as we will not cover all visits today, we will be following up with a more robust and more specific guidance document that will help you understand all LSC visits. Let's get started.
And at the LSC OIG, we have two major units, the Audit Division as well as the Investigative Division, and I am part of the investigative side of the house. Now for the OIG and at the direction of the LSC Board and the Inspector General, of course, we have incorporated a robust fraud prevention program. Our goal is to be proactive in this area, to provide information to the grantees about past and ongoing fraud schemes so you can get out ahead of the fraud issues and set up the proper internal controls and safeguards to prevent fraud from occurring in your programs. And you may ask, hey Dan, what are you doing as a proactive nature in terms of prevention of fraud? Tell me a little bit more about that. Well, okay, I will. Thank you very much for that opportunity. So we do two areas really is fraud prevention, or three. I'll begin with, it's not on the board, but it's fraud awareness briefings. And a fraud awareness briefing is conducted on-site or via webinar, and we'd be happy to set up any type of FAB or fraud awareness briefing for your program. Just give us a call. We can do it via webinar. It lasts about an hour, and we recommend this type of fraud awareness briefing to any new EDs or CFOs to obtain a better understanding of fraud risks that may occur within the LSC grant program. So from a prevention perspective, we do FVAs, fraud vulnerability assessments, and we schedule these visits about 60 to 90 days in advance, and depending on the size of the program, we send between 2 and 5 investigators and usually spend about 4 days on site, usually Monday through Thursday afternoon, to conduct the FEA. So an FEA is a proactive review to assess a grantee's risk to fraud. Again, we want to get ahead and get out and make sure you have the information to prevent fraud. So what do we do? During that period, we review your policies and related materials prior to the visit. We complete an entrance conference, provide feedback to the ED during the visit, and conduct an exit briefing on that last day on Thursday afternoon. We examine how you apply those policies during an on-site review, including reviewing your financial related documentation and allocation methods. Based upon previous fraud schemes investigated by the OIG, we test internal controls to determine if any weaknesses exist at your program that could possibly lead to fraud occurring at your program. And during the exit briefing, we offer suggestions, keyword suggestions, for any needed enhancements to your policies or procedures to reduce your risk to fraud. During the FEA, we don't issue a formal report. We provide recommendations, and our focus is on preventing fraud, giving you the information you need to tackle that problem and not be the gotcha guy as best we can. We want to focus on prevention and not do the formal reporting process. We want to be your assistant, be your agent, be your resource to prevent fraud as best we can. Now, on occasion, there are issues that may come up that we may identify through an FA that may require additional review or follow-up by my office, which could lead to further discussion with OCE in terms of the regs or the issues that we uncovered, possibly a question cost, but that doesn't happen too very often, but it can occur. So there are some issues that may develop from that FVA on occasion. So that's the FVA, the Fraud Vulnerability Assessment. Really reviews your financial area. We'll be working with the accounting staff and the ED for the most part during that 4 days we're on site. And then go into an RVA. So an RVA, or Regulatory Vulnerability Assessment, is usually conducted and scheduled with an FVA. So we call this a 2-for-1 sale. So more or less, we're going to schedule the FVA with an accompanying RVA review. Same people on site will complete those two areas of concern. And as you know, ensuring regulatory compliance is very important to Congress and the LSC board. In fact, a violation of the LSC regulations could cause more harm to a grantee than an actual financial fraud that may occur in the program. Most importantly, we complete approximately 8 to 12 FVAs, RVAs visits per year, 8 to 12 per year, and try to coordinate as best we can these visits with OCE, OPP, and the Office of Audit within the OIG as well. So an RVA is intended to assess a grantee's financial risk based on regulations associated with the LSC Act, related guidelines, and grant assurances. And we collect that type of information or materials, as you can see on the board. And then with an RVA, we focus on the regulatory issues such as outside practice of law, prohibited political activity, restrictions on lobbying, private attorney involvement, program integrity, subgrants, diversion of clients through the intake process, outside employment, bonding of grantees, client trust, and attorney fee issues. That's a lot of work, but we do a lot of planning prior to, and we do our best to get the information we need and talk to you within those 4-day period. But it is a pretty comprehensive review. So that's FVAs, RVAs. That's on the prevention side. Going to investigations, we have a hotline, as you all know, to receive complaints related to fraud, waste, and abuse. We also receive concerns or allegations directly from the EDs and other employees. And as you know, any potential fraud with a loss of $200 or more is required to be reported to the OIG. And again, most investigations are reactive in nature versus an FVA or RVA, meaning we get an allegation and we've got to do our best to vet that allegation and determine whether or not we can just make a call to ED, get some additional accompanying documentation and close it out, or do we have to go on site for a review of that allegation, get more information, and develop the evidence to prove or disprove the allegation. I want to make it clear also that one of our goals is to disprove allegations. And we know that going in, and I can tell you that the majority of cases that we work are disproven. So that happens, but sometimes we can resolve it quickly. Sometimes it takes a little more time. If an investigation does prove wrongdoing, the goal is to hold people and programs accountable and to deter fraud. And then during an investigative visit, 2 or 3 investigators may be on site for no more than a week. We typically communicate with the ED regarding the allegations of concern. Interviews of employees and witnesses will occur. We will request documentation associated with the specific allegation, and then significant analysis may be required of more of the complex issues that we get into. An investigation will result in a report of investigation. Our report will develop the facts and other supporting documentation to prove or disprove the allegation. If an issue results in a potential criminal violation, the ROI will be referred to a prosecutor for their decision. And we have some additional types of reports that may come through our investigative program, which is question cost, which we all most know about, meaning our cost that is not adequately supported by cost in terms of LSC standards. A management information memorandum where we may discover a systemic weakness which requires attention from LSC management. We do different program initiatives or projects as well to test investigative theory or to gather more information on a specific program where we need more information, or maybe we believe that program area might be vulnerable to fraud. So, and then sometimes these program initiatives can lead to best practices. We find that particular grantees are doing a great job in a particular area that we want to share with other grantees across the country. And then fraud alerts is when we have a common fraud scheme or pattern that could impact grantee or operations. When we get that information to you as quickly as we can with best practices so that you can, again, be aware of it, educate you, and provide best practices to prevent that particular fraud that may be occurring in different programs. And then fraud corner articles is a specific instance of fraud that either through LLC programs or within other grant making programs that we want to bring to your attention. We just issued a fraud corner article on nepotism. We talked earlier about a fraud corner article on insider threat related to information technology and related to phishing schemes. And that's my area of discussion for program visits for the OIG for investigation.
Good afternoon, this is Roxanne Caruso. I'm Dan's counterpart in the Office of Inspector General, and as always, Dan gets to talk about the exciting things. I get to talk about audit. So, so I will talk today about the visits that the audit division conducts to grantees to perform audits. The type of audit that we most commonly conduct is of selected internal controls. The purpose is to assess the adequacy of internal controls in place over grantee operations, including program expenditures, fiscal accountability, and compliance with LLC regulations. Essentially, our mission is to ensure that congressional funds are spent appropriately, efficiently, and effectively. A team of auditors from the Office of Inspector General conducts the on-site visit. Generally, the team consists of 3 to 5 individuals, and an auditor in charge leads the team on site. Usually there are between 2 and 4 staff auditors that are also on the team. While on site, the audit team interfaces and meets with members of grantee staff, including the executive director, the chief financial officer or equivalent position, accounting and financial staff, human resources staff, payroll administrators, and others as needed. At the outset of the visit, we normally ask grantee management to designate who on their staff they prefer serves as the primary contact for the audit team. Generally, we find it's the executive director, the chief financial officer, or a supervisor on the fiscal staff. And during the visit, the auditors conduct interviews with staff. They gather and review information. They review policies and procedures and observe work processes. Usually accounting and financial staff are most involved, but we do meet with other members of grantee staff as needed. In terms of the materials requested and required for the visit, in advance of the visit, the auditor in charge emails a documentation request to the executive director of the program. We try to do this in as far in advance as possible in order to allow grantee staff the appropriate time to gather and submit the documentation. Generally, we send those out 2 to 4 months in advance to the on-site visit. And the request includes a number of items such as the grantee's accounting manual, any administrative or personnel manuals, accounting information such as the general ledger, chart of accounts, check register, fixed asset records, and cost and derivative income allocation methodologies. At any point during the audit, on-site or before or after, the auditors also may follow up with staff to request additional documentation. In terms of the mode of transmission of documentation, the OIG usually asks grantees to upload electronic documentation to a shared folder. We find that that works best. And we also ask grantees to gather and provide hard copy documentation that will be ready for the auditor's review when they arrive on site. The result of our on-site visit is an audit report conducted in accordance with government auditing standards. There are several stages to the reporting process, and the first of that is an exit conference. Prior to the conclusion of the visit, generally on the last day, the audit team conducts a meeting with grantee management to discuss the preliminary results of the audit. And the purpose of that meeting is to ensure that grantee management is aware of any issues that were identified and to openly discuss the matters. We strive as a team to be transparent as possible throughout the process and operate in an environment of no surprises. So to that end, if we encounter any issues during the audit, we will communicate them with grantee management as they arise. The next step of the reporting process is issuance of a draft audit report. The report summarizes the findings and recommendations of the audit, and we issue the draft report to grantee management for review and comment. It's addressed to the executive director, and we ask that they respond stating what actions, if any, they have taken or that they plan to take to address the recommendations contained in the report. And we provide grantees 30 days to respond. And their response in its entirety is included in the final report as an appendix. And the final report with the grantee's response is issued to the executive director and copied to the grantee's board of directors, LSC's president, Jim Sandman, and Vice President for Grants Management, Lynn Jennings. In total, throughout this whole process, we strive to make it a process that provides valuable and actionable feedback that helps grantees ensure that congressional funds are spent in accordance with regulation and as effectively and efficiently as possible.
Okay, thanks so much, Dan and Roxanne. So we're going to move on to the Office of Compliance and Enforcement. Laura, would you like to
I will
get
kick it
us
off.
started? Okay.
Yes, thank you, Dina. Thank you, everyone. My name is Laura Rath, and as Dina said, I am the Director of the Office of Compliance and Enforcement. Our office conducts several different types of visits, but for today, I want to concentrate on the 3 that we do most frequently, which your grantee will most likely experience. So moving on, the first one I want to talk about is the compliance review. For those who have been in legal services arena for a while, we used to call this the Case Service Reports Case Management System Review. About 5 years ago, due to the number of new areas we were looking at, we decided to rename it the Compliance Review because it's basically a soup to nuts review of your program. It focuses on fiscal and regulatory compliance with the LSC Act, regulations and guidelines, as well as accurate case service reporting. And the review also focuses and assesses on the strength of a grantee's fiscal health and internal controls against the Accounting Guide for LSC grantees and other fiscal standards. These reviews usually take place over a 1-week period, but can be shorter or longer depending on the size of the grantee, the number of staff, and the number of different offices and projects that your organization has, because we want to review and assess every office while we're there. When determining which grantees to visit every year and what type of visit to do at that grantee, we look at many different factors. For a compliance review, some of the most significant factors are listed on this slide. We don't have, for the time since the last compliance review, we don't have a definite cycle for how frequently we visit someone or visit a grantee, but we don't like it for it to go too long. Most grantees are visited at least every 7 years at this point in time. Self-inspection, error rates can be that you've had high rates for several years in a row, the rates sprung up from one year to another, or even having consistently low rates are something that we look at. And then, as Dan mentioned, sometime the Office of Inspector General or even the Office of Program Performance relay concerns to us that are outside of their lanes of review that we then go on and look at when we go on site. Some of the other things we look at are issues noted in your audited financial statements and the number and significance of complaints lodged against you with the corporation. When we're trying to make each of these visits as useful and as smooth as possible for both the OCE staff and for the grantee, so we ask for a lot of information in advance of the visit. This screen just lists some of the documents that we ask for. Roxanne, in her explanation listed a lot of things that the audit division looks at that are similar to what we ask for. I'm not going to go into every item, but I just wanted to explain with the case list, we're going to ask for 2 years of your CSR reportable cases, as well as any cases that are open or closed in the current year. And that's because we want to look at the patterns of how you've been doing compliance-wise. We want to see how things have changed over the last 2 to 3 years. We ask for a variety of program policies and procedures because we want to make sure they comply with LSC regulations, and then we want to make sure that your staff are following your own policies and procedures. In order to assess fiscal compliance and health, we ask for access to general ledgers, cash receipts, various timekeeping and personal activity reports, as well as your property records. And if you've received a special grant from LSC in the last 5 years, we're going to ask for information regarding the use of those funds. Before we get on site, we'll ask for various documents, such as the ones listed on the slide, that they be available in hard copy when we arrive. And much like Roxanne talked about with the audit division, we ask that the documents requested in advance be sent to us electronically. We have a box folder and we provide support to you for uploading those documents to us. And we usually we send the document request letter out anywhere between 4 and 6 months in advance and ask for the documents to be to us about 45 to 60 days in advance. Okay. The on-site review process has lots of moving parts. And we have the team is made up of attorneys and fiscal experts. The attorneys are going to do case review, and going back to even before we go on site, we will negotiate with you how we're going to do case review and how we're going to look at the sample cases. In most cases, grantees use intermediaries who answer questions that are asked by the attorneys, and in advance of the review, we give you a list or the actual form that we use when reviewing cases, so you know the type of information that we're going to be asking for. We also do a lot of interviews. The next 3 areas are the areas where we're going to interview staff about. In addition to interviews, we're going to ask staff whether we can observe intake or whether we can do practice intakes with your intake staff. We're going to test your case management system to see how well it runs reports. And the fiscal staff is going to test various transactions to determine internal controls and whether they're being followed. At the end of the review, before we leave, well, first of all, every day at the end of the day or the early next morning, the team leader will provide the executive director their preliminary findings from the day before or the day of, so that when we do an exit conference on the very last day of the visit, when the team gives their preliminary findings, nothing will be a surprise. So the preliminary findings given at the end of the week are just a roll-up of things that we've been sharing with the executive director throughout the week. After we leave, our goal is to provide each grantee with a draft report within 60 days of leaving the program. For statewide programs, our goal is 90 days. We've been fairly successful in meeting that goal for the last year because anyone who's received a recent visit will notice we've changed to exception reporting. So your report will only list those areas in which we had a compliance concern that requires corrective action be taken. Anything where there was compliance, it will just have a check mark saying that we reviewed it. We will not go into detail as to why it's compliant. We wanted to concentrate our efforts on and yours on the areas that need improvement. The grantee then has 30 days to comment, and in those comments they can tell us we misunderstood something or got something wrong, and then we'll negotiate with you to make sure that we update the report correctly, and also provide updates on any plans to take corrective action or to provide evidence of corrective action taken. And I want to make it clear that we don't expect grantees to finish everything in that 30-day period. We want you to be thoughtful in considering the actions we want you to take. So it is perfectly fine to respond to us what your plan of action is going to be over the next 3, 4, 6 months to complete a required corrective action, rather than rushing through to finish something in 30 days. Then we incorporate your comments into a final report, and much like the audit division in the OIG does. We include your comments in their entirety as an attachment to the final report, which is issued to the executive director and the board. If there are any required corrective actions that are still open when we issue the final report, we will continue to conduct follow-up both by letter and by phone until we receive evidence sufficient to close all of the required corrective actions. Let's see. The next type of review that I want to talk about is the technical assistance review. We've been doing these more and more frequently, especially with the addition of Dina and her team. These reviews are designed to help grantees, both the management and the staff, learn and understand where there are deficiencies in their policies or opportunities for improvement. We focus on many of the same areas that we do in a compliance review, but it's to help newer EDs and the grantees in a I don't want to say a safer environment, but in a more collaborative environment rather than us coming in and doing an actual monitoring visit. The things that we take into consideration when scheduling these are oftentimes grantees are asking for assistance. So we find it better to go in and do a technical assistance review than doing a compliance review. Especially, as I said, it's helpful to new executive directors and also to new chief financial officers. Or if we've been out on site and the grantee just isn't able to resolve concerns that we had from a prior on-site review, we'll potentially go out and do a technical assistance review to help them get over that hump and resolve the pending issues. The materials requested in advance of a technical assistance review are very similar to the compliance review. And the reason why we ask for so much information is we're really trying to make it very particularized and specific to each grantee. So we're reviewing almost all of the same information as we would for a compliance review because we want to know as much about the program before we get there so we can tailor our trainings to the needs of that grantee. And one of the things we're doing to also help with that is this year we're starting to do brief pre-survey, pre-visit surveys to enhance the training. So I would ask if you're an executive director or senior management talking to the team leader, and once you're a staff member doing the pre-surveys, please be as honest as possible in answering the survey because it will make the visit that much more beneficial to you and the program. For a TAV, the length of it depends on the number of offices and number of staff because we want as many staff to be able to participate as possible. We will often ask that staff from one office travel to another office so that staff from two different offices can work together because we find that working together, they are able to come up with better opportunities for improvement than if they're just looking at their own work. The general review areas are much the same as for a compliance review, but we do it a little bit differently. Typically, we break it into morning and afternoon sessions each day. In the morning, the attorneys will do a little bit of review about the intake-related regulations and teach legal work staff how to do case review. So they do the same case review, teaching them to do the same case review that we would do if it was a compliance review. And we give your staff the forms that we fill out, and we let them actually review the cases with our assistants. We don't sit with them, but we kind of walk around the room and answer questions, and we let the staff find their own areas or challenges that they're seeing in their colleagues' cases. At the same time in the morning, another group of our staff will be interviewing staff who do intake and private attorney work, interviewing your fiscal staff, and testing some of the internal controls. Then in the afternoon, everyone regroups, and based on the findings and observations and questions that were asked in the morning, we'll give specific training on the areas that were, the most concern or where the most questions were raised, so that way it's tailored specifically to the needs that we're seeing that day. For these reviews, I wanted to mention that oftentimes it's made of both attorneys and fiscal compliance analysts, but we're finding that sometimes a grantee just has issues on the compliance side or on the fiscal side. So we're doing more and more just sending the fiscal team out by themselves. So then it would just be your fiscal staff who's involved in these reviews. But again, it depends on the specific needs of a particular grantee. Benefits of this, as I keep saying, you know, your staff is involved in it. So they have instant access to the results. So it's easier for them to immediately think of ways that they can improve or suggestions for improving how the program does things. One of the other benefits is there isn't an actual report. Instead, we issue a letter. We try and do it within 60 days. Oftentimes it's in a much shorter amount. And in it just summarizes the different areas that we saw, the different recommendations that we made so that you then have it in writing. And I think the biggest benefit is that your grantee and your staff get to meet the OCE folks and realize that we do want to offer guidance and assistance so that this way they're not as hesitant in the future to call up and ask questions or to ask for some guidance. So. Okay, the next one I want to review is the follow-up review. And this one, so the purpose of this is to assess whether the grantee has taken sufficient steps to address required corrective actions noted during a prior OCE visit. Not every program or grantee that has a compliance review will have a follow-up review. The factors that we look at in considering whether to schedule a follow-up review are the number and severity of the required corrective actions. So if there are a lot of required corrective actions, you know, that weighs towards maybe we should go back and see how they're doing. The severity, if it's something simple, like there were a few retainer agreements missing, that's not so severe. If there was a lot of violations of citizenship and alien eligibility, that's severe. So we would weigh that more heavily. But the biggest factor is the grantee's responsiveness, whether they were able to cure the deficiencies quickly, whether they responded to our requests for updates, and how confident we feel in the information that was provided to us in response to our questions. So those are the things we consider when deciding whether to do a follow-up review. And we try and do those within 12 to 24 months of finishing a compliance review. A follow-up review is very particular. So your document request letter, it could be very big or it could be very small, depending on the number of required corrective actions that we're going to be following up on. If it's just a few, we're going to ask the questions just based on those few required corrective actions. However, if you had 30 required corrective actions, we're going to be asking for a lot of documentation. So it's very particular and specific to the actual grantee in question. And sorry, we are a couple slides behind. What we look at, the on-site activities are then, much like the document request letter, it's driven by the required corrective actions that we're going to be reviewing. So these are the subject areas that we may or may not be reviewing on a particular visit. Again, as I said, it depends on the required corrective actions. And with that, a visit can be anywhere from 2 days to 5 days, depending on how much work we're going to have to do on site and how many different areas we're reviewing. The post-review follow-up, again, depends on the situation. If we go on site and find that the grantee was able to satisfy all of the required corrective actions and we're just dotting our I's and crossing our T's, we will just issue a simple letter saying what the required corrective actions were, what the steps taken were, and letting you know that there's no follow-up needed. However, if there are required corrective actions still pending, or if we discover new required corrective actions that might be needed, we're going to issue a draft report, much the same as the compliance review report. It will be an exception report. It will be issued within about 60 days of leaving the site visit. But again, the grantee will have, again, the same 30-day comment period, and then the same final report with the comments attached to it. And again, ongoing follow-up as necessary until all required corrective actions are closed. So that is a brief overview of OCE visits.
Great. Thank you so much. We're going to move on to Joyce McGee, the Director of the Office of Program Performance. Joyce?
Hi, thank you, Dina. So I'm going to talk about the visits that we conduct in the Office of Program Performance. We have listed here 3 visits: program quality visits, program engagement visits, and technical assistance visits. We also conduct a 4th type of visit, which is called a capability assessment visit that only occurs when we have more than one entity applying for funds for the same service area. So in the essence of time, we will not discuss that type of visit here, but we will include information about it in the materials to follow. So I'm going to start with our program quality visits, which are our largest visits and where we review a grantee's organizational capacity to deliver high quality legal services. We use the LSC performance criteria as our guide, and on these visits, we interview management, staff, board, and community partners. We do not interview everyone on staff, but we try to be very strategic about which offices we go to and which staff that we talk to. Every grantee has an assigned program liaison, and that program liaison is usually the team leader of any visit to a grantee. There are instances where we have new program liaisons and we may have to have a more experienced program liaison run a visit, but typically your liaison is who will lead the visit. Team size will range, is all dependent on how big your organization is. It's determined on your staff size, your geography, your number of offices. You may have, there may be some characteristics within your program that may actually require more resources, and if there are certain issues that we may be aware of that we have to have specialized knowledge about. Maybe you also have additional service areas. You have an agricultural worker grant, and you have another service area for Native American work. And so we will look at all of those pieces. But we use the LSC performance criteria is broken up into 4 areas, and we assign team members to specific performance areas, but the team works together to develop findings and recommendations. The team participants will be the liaison and other program counsel within our office, and then also 1 or 2 temporary employees may be on the visit. Those temporary employees, many of whom are former legal services executive directors or staff. The timeline for program quality visits is lengthy. Grantees will be notified well in advance of the start of this timeline that you see on this slide, and we will typically ask for an updated staff roster at the time we agree upon a date for the visit. This helps us determine if there have been any changes since you last reported staff in the grantee activity report the prior year. All of our visits are usually determined by the start of the calendar year. This timeline shows the process after a visit date is agreed upon and the program has discussed the upcoming visit with their program liaison. Grantees receive formal notification of the visit 75 days prior to the start of the visit, and grantees are given 35 days to submit documents requested. Prior to the visit, a staff survey will also be issued to the entire staff. An interview schedule will be developed and worked on in collaboration with the grantee. The on-site visit starts with an entrance conference, then moves to interviews of staff, the board, and community partners. An exit conference is held at the end of the visit where we verbally present preliminary findings and recommendations. So the materials that we request for program quality visits help us prepare for the on-site visit. For example, under Performance Area 1, we ask for documents related to a grantee's needs assessment, statement of priorities, strategic plan, mission statement, outcomes data. If the grantee has already provided LSC with this documentation, we remove it from the document request and just ask for an update. We ask for documents specific to each of the 4 performance areas in the LSC performance criteria. If the materials to be provided, we will provide a more exhaustive list of the specific documents that we ask for. After the visit, we issue a report within 60 or 90 days, depending on the size of the grantee organization. The report will include findings and Tier 1 and Tier 2 recommendations. What Tier 1 and Tier 1 recommendations are intended to have a direct or major impact on program quality and/or program performance. And grantees are required to respond to the Tier 1 recommendations following the visit. So program engagement visits can serve a number of different purposes, including being an informational gathering visit, a follow-up to a program quality visit, or prior recommendations, and/or to address an area of concern. We have many new program liaisons within the Office of Program Performance and have shifted some of our seasoned program counsel to different grantee programs. So many are learning about the work of each of the grantees, and program engagement visits can serve as a great purpose of helping to inform program liaisons about the organizations. The participants at these visits are usually 1 to 2 people. It's usually the program liaison, and sometimes we will bring somebody with an area of expertise. If we were focused on, say, your pro bono program, we might bring somebody from the Pro Bono Innovation Fund staff. Or if there were some technology issues, we may be bringing somebody from our Technology Initiative grant program. So the timeline for program engagement visits, they are usually covered in 1 to 2 days and usually include an interview schedule. Depending on the purpose of the visit, we will focus our interviews on to cover whatever the area is that we are focusing on. But it's usually a much more scaled down interview schedule than we have with our program quality visits. I like to refer to the program engagement visits as a much lighter touch than the program quality visit. The materials requested for program engagement visits also varies depending on the purpose of the visit. Typically, program liaisons ask for updated information and data to help assess progress or to learn about the program. The documents requested are, of course, much less than what we require in a program quality visit, but are still centered on the LSC performance criteria. They're just usually focused on a very specific area of the performance criteria. So for example, if the purpose of the program engagement visit centers on intake, we may only ask for updates to your intake manual. We may ask for some current intake data. We may ask for any updates to your limited English proficiency plan. We may ask for reports on client satisfaction or any changes to your intake policies or procedures for staffing or any changes maybe to your hours of intake. So in that particular instance, in that particular example, we would also then probably interview mostly intake staff and management. Actually, could you go back one slide? So for the program engagement visits, we typically will send you a letter within 30 days of the visit that summarizes what we've observed and then also may address some next steps. Sometimes we have some informal recommendations that come with that, and your program liaison will work with you to work on those recommendations. Our third type of visit is the technical assistance visits, and the purpose of these are usually laser focused on an issue or area that a grantee needs assistance to improve. Sometimes these visits are requested by the grantee, but typically they are conducted to address an area that the program liaison identifies as requiring attention. These visits are conducted by the grantee's liaison and sometimes will include a member of our training and technical assistance team. Dina, I'm not sure how long you've been in existence, but for the last year at least, we've had training and technical assistance staff sometimes join our liaisons to help provide the technical assistance. It really depends on what the technical assistance is specifically for. We've conducted technical assistance on board governance, intake, strategic planning, pro bono activities, needs assessments, leadership. It's a pretty long list. And these visits typically involve collaborative planning with the grantee leadership to help shape what the agenda is going to be, what the goals are going to be, what the objectives are going to be. And depending on the specific technical assistance being provided, it's usually a 1 to 2 day visit. It just depends on how extensive the technical assistance is needed. And the materials that are either requested are usually centered on what the area of focus is for the technical assistance, but of course varies significantly depending on the area of focus for the technical assistance.
Excellent, great, thank you so much. So we've got about 10 minutes left. I wanted to field just a couple of questions. So I will pose these questions to the respective folks. So the first question that's come in is for Joyce, and the question was, how can we better coordinate data requests with the data they already have for grantee reporting and from other visits?
So that question I take to mean that how can we not ask for the same thing over and over again? We are well aware of how much of a burden we have put on grantees to supply us with the same documents over and over again. Part of the reason for that is that sometimes we have been very siloed in where we collect and save our documents. We are moving into the future with a new grants management system this year that I think will help improve our ability to know what we've already collected from our various different visits. I say that for OPC, the Office of Program Performance and the Office of Compliance and Enforcement, but there's still a firewall between us and the OIG for obvious reasons. And but as we move into our new grants management system, which is very grantee-centric, we should be able to lessen the multiple requests that you get in terms of documents.
Awesome. And one other question came in, and you touched upon this a little earlier, but someone asked what the specific meaning of tier 1, 2, and 3 are.
So we don't have 3, we only have 2. You either have a tier 1 recommendation or what we call a tier 2 recommendation. We only issue these recommendations through our program quality visits, and programs are required to respond to the tier 1 recommendations for a period of 2 years following their visit. We refer to tier 1 recommendations as those that are that have a direct and major impact on program quality and/or on program performance. And it's only the tier 1 recommendations that we require formal response to following the visit.
Awesome. Okay, we've had a couple of OCE questions come in. So Laura, what are the standards of evaluation for the program integrity visits?
That's a good question, and one I didn't even touch on, and probably one that I'm just not really gonna punt, but I'm gonna tell you that it's based on the totality of the circumstances. And because all of the parent-child relationships are different, so I can't tell you what the standards of review are. I would say to review Part 1610, specifically subsection 7, which tells you the different criteria that we look at. And then again, as I said, it's the totality of the circumstances. There's not one factor that weighs more than another. It's looking at the whole situation. We take those reviews very seriously. We do a lot of pre-visit work for those. The document request is very large. When we go on site, we look at things like the square footage that each organization is using, if they're shared spaces. And we don't make any We rarely make preliminary findings because we bring it back and we talk to our Office of Legal Affairs because we want to make sure that we're applying it correctly and that we're applying it evenly to any grantee that does a program integrity review. So I hope that answers it a little bit because there's no definitive answer. It's just everything's different.
Okay. And we've also had several questions come in today about indirect costs. Can you speak to that a little bit for
Yeah.
visits?
Yes, so indirect costs and cost allocation is something that we are definitely looking at more closely as we have beefed up the number of fiscal compliance analysts on staff. So we will ask for your cost allocation methodologies for both direct and indirect costs as part of a compliance review. And we recognize that as we've been looking at it and paying more attention to this area, that grantees are having to do a lot of work to revise their policies to make them compliant. And we are very happy to work with the grantees to develop a compliant policy. Reach out to me or to Stuart Axenfeld and we'll put you in touch with your fiscal compliance analyst if you have questions about whether your particular policy needs to be tweaked. I also suggest that you review program letter 18-2 that we issued in about, I think it was August of 2008. And we also put together, thanks to Dina, a webinar that was issued last year, specifically looking at 1630.5 and different things that a grantee should keep in mind when looking at their cost allocation methodology.
Okay, so in the interest of time, we're going to wrap up. I wanted to follow up with just a couple of next steps so you're not left without any resources moving forward. So our plan moving forward is to provide you all with a more detailed visits guide. We hope this will help you to a more focused resource. These guides will summarize each of the visits discussed today, as well as others that may not have been discussed. So this will be coming soon. And like I said, we hope this will serve as a really great resource before our staff come on site. We do realize that there were other questions that we were not able to get to today. So if we were not able to get to those, we'll run a report and then we'll follow up with an FAQ that answers some of the more significant questions very shortly as well. If you do have any questions on these visits, please don't hesitate to reach out to your respective program counsel or your respective fiscal compliance analysts. Those liaisons can be found in each of the respective offices in both OPP and OCE. So we're going to wrap up the webinar there. I will encourage you to stick around after I end the broadcast. We have 3 survey questions that will pop up right at the end of the webinar, and these will help us in planning future webinars. So thank you for your participation. We look forward to doing many more of these in the future to help you out with understanding Legal Services Corporation's policies, procedures, and visits. Thanks so much.